Mr. Wingate, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. Wingate, first let me ask, Mr. McKinney, how are you involved in this plea agreement?
Judge, I represent Mr. Wingate in case number 23CF2020, which is included in this plea agreement.
Good, okay. Mr. Wingate, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
7th grade.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorneys?
Yes, sir.
Did they answer your questions?
Yes, sir.
Are you satisfied with their representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Wingate, did anyone force, threaten, or coerce you into entering this plea?
No, sir.
Has anyone promised you anything other than what's in the written plea agreement?
No, sir.
The other side of that, Mr. Wingate, have either one of your attorneys told you if you fail to enter this plea today, you shall be sentenced to 15 years in prison or any other definite sentence? Okay, what did they say to you? Did you understand the question?
Oh, can you repeat that one more time?
Sure. And the reason why I asked this question is to make sure that someone didn't tell you, if you don't enter this plea, you're going to go to prison for 15 years. Because no one else knows what you would be sentenced to if you went to a jury trial. Because I don't know what I would sentence you to if the jury found you guilty. So to make sure you weren't coerced, has anyone told you if you do not enter this plea today, you shall be sentenced to 10 years in prison or any other definite sentence?
No, sir, not mandatory.
I'm sorry?
I said, no, sir, not mandatory.
Okay.
I
Meaning-
can clarify, Your Honor.
Please.
In my case, Patrice Cash on behalf of Mr. Wingate, in case 23 CF 2011, I showed the video to Mr. Wingate as well as his mother and told him for the fleeing and eluding that if we went to trial, we would lose the fleeing and eluding, and there would be a very great chance that he would probably get more prison time than what's contained in the plea agreement.
Okay. So, Mr. Wingate, no one has said you shall be sentenced to something if you go to trial, correct? Okay. Do you understand my question? Okay. Do you have any questions for me or your attorneys or the state?
No, sir.
Mr. Wingate, did you sign the plea agreement?
Yes, sir.
Mr. Wingate, I do accept your plea. I find that you're alert and intelligent, that you understand the terms of the settlement agreement, and that there is a factual basis for the entering of it.
Yes, sir.
So the sentencing will be set for July 11th at 9 o'clock. So what happens if Mr. Wingate's not here on July 11th at 9? Ms. Cashwell?
Your Honor, my understanding of the law is that you would be able to sentence him in absentia, that he's voluntarily absented himself from the sentencing hearing, and that you would be, it would be permissible for you to sentence him up to the statutory maximum, which would be 30, at least 30 years state prison, and that's not, and then we've got the misdemeanors.
Yes, ma'am. Mr. Wingate, do you understand, and I think you could be sentenced maybe to 60, 80, I mean, you could add up those maximums at the top of your plea agreement. Do you understand that you could be sentenced to 30 years or more if you don't show up on July 11th?
Yes, sir.
Okay. Very important for you to be here for this. Okay.
I don't mean to cut you off, but I also have ankle going on too, so I got to check in today, Thursday.
Okay. Good. So I'll see you July 11th at 9 o'clock. Good luck getting your braces off. Your teeth will feel very strange when they come off. They did when I ran my tongue across mine 1,000 years ago. So I'll see you on the 11th.
Okay, thank you.
Thank you, sir.
And Your Honor, thank you for letting us do that.
Yes, ma'am. You're welcome. Okay, then, I don't know if we have any pro se's. Thank you, ma'am. Yes, Ms. Tassin? And it's 19 CF 188. Ms. Tassin, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
I'm at $15, so
What do you think you average making per month?
maybe 35.
3,500 a month? Okay. You're probably not going to qualify for the public defender, so I can't appoint the public defender right now. Does the state have an offer for Ms. Tassin? TA? Right.
I believe that's something that we can work out probably. It wouldn't be a situation where it would be some type of probation or diversion. I'm not sure. I have to see the values of the promissory notes.
Okay.
Your Honor, I think on this case, the state, and I'm sorry to cut you off, David, on this case, the state would be willing to, if she admits the VOP, because this is a VOP, correct?
Correct.
And I'm just looking at our notes in our case file with the offer. I think it would be, there was a withhold, we would maintain the withhold, revoke and terminate your supervision. All outstanding financial requirements would be due within 20 days, then to collections. There's a $150 cost of prosecution fee. So if that's what you would like to do, that would be what the state would be willing to do right now, Your Honor.
Okay, so Ms. Tassin, what all that means is, it would be, you'd be waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you. So you'd basically, you'd not be contesting that, you'd almost be, you'd be admitting that violation. It would be a withhold of adjudication. Your current supervision would end immediately today. If you failed to pay all of the outstanding money within 20 days from today, then it will go to a civil lien or judgment that may adversely affect your driver's license, okay? And any welfare, anything else you may be on. There would also be an additional cost of $100 cost of prosecution. If you want some time to talk, to hire a private attorney, you can certainly do that. It's up to you what you want to do,
I'll gladly accept the plea.
okay?
Thank you.
Okay, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. So, Ms. Tassin, did you understand everything that I previously said today on the record?
Yes, sir.
Do you understand what your sentence will be?
Yes, sir.
Any questions for me or the state?
No, sir.
Ms. Tassin, I do accept your plea. Adjudication is withheld. Your current supervision is revoked and terminated today. If you fail to pay all of the outstanding fees and costs and restitution within 20 days from today, including the additional $100 cost of prosecution, then they'll go to a civil lien or judgment. Okay? Thank you, ma'am.
Can I have the individual in the gallery?
Certainly. And then also remember, Mr. Strong, and you don't have a Zoom. Usually it comes straight across from the photo. Thank you, ma'am. Good. Thank you. Yes, sir.
Your Honor, this is Mr. Taylor Muncy, 23 CF 1085. We have reached an agreement to resolve this case. At this time, Mr. Muncy is going to be entering a no contest plea as charged. The agreed upon terms of the sentence will be that he will be placed on 2 years of probation. He will have no contact with Kevin Ledbetter, and that's spelled Ledbetter.
I'm sorry, who's the offender?
Muncy.
Number 14 on the docket.
Yes, ma'am. It's LED. Okay. He'll complete anger management program as a condition. He will perform 24 hours of community service, which he can buy out. He'll be assessed $610 in court costs, $150 in public defender fees, and there would be a withhold of adjudication. Is it 967? It's because of the administrative charge. It's 967. Well,
And there's also $40 per month cost of supervision, right?
yes, sir.
Okay?
May I
Yes, sir.
approach? There's no objection to that score sheet.
Thank you. But before I swear in Mr. Muncy, and it didn't hit me until I saw Mr. Muncy, I think on Monday, that I see Mr. Muncy at Mary's Kitchen and say hello to him, and he says hello to me, but it didn't hit me until then. I thought, wait a minute.
Oh, he's a
Mr.
super nice
Muncie's
guy.
from Mary's
Every time I call him on the phone, he's like, "This is Taylor." You know?
Yeah. Okay, so I just wanted to disclose
Yes,
that.
sir.
Mr. Muncy, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Mr. Muncy, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
As far as I know, yes, sir.
Okay. Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Muncy, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. You'll have no contact with the victim, and that's direct or indirect. Don't post anything directed at the victim. You'll need to enter and successfully complete the anger management course. Perform 24 hours of community service work, however you can buy that out. You'll need to pay the court costs, $150 public defender's fee, and the $40 per month cost of supervision. Thank you, sir.
Thank you.
Good luck to you.
Thank you.
Good luck, Taylor.
Thanks.
Yes, sir.
Morning,
Mr.
Judge.
Cox. Good morning, sir.
Your Honor, if I can call the case of Mr. Dustin Strong, who's
Good.
virtually...
Yes, sir. Mr. Strong was on Zoom at 8:30 this morning.
Mr. Strong, if you can unmute your device. I got your video, just if you can unmute, please.
There you go. Yes, sir.
Your Honor, we're here in case number 23 CF 1659. Ultimately, count 1 is going to be no prost, leaving count 2, possession of drug paraphernalia, first-degree misdemeanor. My client is ready to enter a plea virtually to adjudication of guilt on possession of paraphernalia, court costs with $150 cost of defense, Judge.
Okay.
It's actually going to be 2 counts of POP.
Okay.
So you're going to file an amended information? Right? Or is it, or are you doing a lesser included on
Lesser
count
included
1?
on Count 1, and then as far as count 2.
Okay. Mr. Koch, you okay with that?
Yes, and Mr. Strong, the only difference in what we've talked about, we're still getting rid of that felony count. It'll be just 2 counts for paraphernalia misdemeanors, but same adjudication of guilt and court costs.
Of the 2 misdemeanors?
Okay. Yes, Your Honor.
And so is it time served? What is the sentence?
Yes, Your Honor, be adjudication of guilt, credit for time served, court costs,
Okay,
and $150 cost of defense.
good. Mr. Strong, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, sir. You can put your hand down. So, Mr. Strong, do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Correct.
Has anyone forced, threatened, or coerced you into entering this plea?
No, sir.
Okay. Do you have any questions for me or your attorney or the state?
No, sir.
And you understand what the plea, what the sentence will be?
Yes, sir.
Okay. It'll be time served, correct?
That's what I just heard, correct. Yes, sir.
Okay. Mr. Strong, I do accept your plea. You're adjudicated guilty. Your sentence credit for time served. You'll need to pay the court costs, $150 public defender's fee. Mr. Koch, how long does your client need to pay those?
Could we get 6 months, Your Honor?
Yes, sir. So, Mr. Strong, if you fail to pay those amounts within 6 months from today, then they will go to a civil lien or judgment. Okay?
Yes, sir.
Thank you, sir. Good luck to you.
Thank you. Have a great day.
You too. Yes, sir. Who's next?
Judge, we call Ms. Katrina Smith.
Hello, Ms. Smith.
Judge, this is in case number 2023 CF 1133.
Yes, sir.
My client did appear virtually on Monday for docket day. We stated the last offer that was on the record that's still available this morning. Ms. Smith, any questions on that offer that was discussed on Monday?
Just for the record, what is the offer?
Yes, Your Honor. It would be counts 1 and counts 2, adjudication of guilt, 4 years standard probation, has a $40 per month cost supervision, $515 in court costs, $150 in defense costs, 75 hours community service, no trespassing at the Old Navy, anti-theft class, maintain gainful employment, or 5 job applications per week. The court will reserve jurisdiction to determine the restitution for 90 days. And there's an automatic termination of probation after 36 months if all conditions and costs are satisfied and there are no violations. Count 3 of the information would be adjudication of guilt and credit for time served.
Okay. Has Ms. Smith ever been adjudicated guilty of a felony before?
Yes, Judge.
Okay. So, Ms. Smith, if you want to accept that offer, we'll talk about it. If you don't, then we'll schedule it up, your case up for trial either next week or the week after that. What do you wish to do?
I want to schedule for trial.
Okay. How many days will it take to try Ms. Smith's case?
Defense believes it would be 1 day trial.
Most likely one, it could go into 2, but I think it would be one.
Okay, so a pick and go in 1 day?
I'm kind of concerned about that.
So 2 days?
I would think we would need to schedule 2.
Okay. Okay, so
So
when do you want it
I
to be?
have 2 officers that aren't available the first week.
Okay, so the second week, June 3rd?
Judge, I think Ms. Rodriguez Barnes' trial is supposed to be the full second week.
Is that what's happening on that case?
And yes, I believe ASA Sandler had sent, we didn't know if there were going to be any other judges that were available that second week, because originally I had quite a few trials, so we sent an email back in March, I think, kind of hoping to prepare the court that there may be, and so we didn't know if, is there any judges that are available the second week?
I will, after I know what's going to happen. So I would suggest that we schedule up Ms. Smith's case today. And then I ask, we get, it's the boy crying wolf. I need to wait until I know that I actually have something. Then I'll ask Judge Ketchel first, and then the other judges, and then ask, I doubt they'll appoint a senior judge to do that, but I can ask other judges if they can do it. So,
If we could schedule Rollison and this case for the second week, maybe on a Tuesday and a Thursday.
okay, well, this is going to be,
Hear motions in limine on Thursday, a week from today, for both of those cases.
okay, are we going to be in a jury trial a week from today?
No, sir. I've got both of my cases, I have witnesses that aren't available the first week.
I understand, but am I going to be in trial on Thursday? You may not be, but,
Well, correct, you're right, but I know you had the 12:30, I didn't know who was doing that, so, you're right.
I mean,
I didn't consider that.
if the motions in limine aren't going to take that long, then, I just hate to inconvenience a jury more than I have to. But that would also be a way on Thursday, if I can't get coverage, then everybody will be here and I can say, we can't do it, we've got to continue. I mean, I can email y'all earlier and let you know, but formally I can do it on Thursdays. So I think that's a good idea.
Okay.
So Thursday at 12:30, motion in limine,
Yes, sir.
and then Tuesday, June 4th, for Ms. Smith's case.
Thursday, June the 4th is what you said, or Tuesday?
Tuesday, or do you want Thursday, June 6th?
Let's do Thursday, June 6th.
Okay.
And then Tuesday, we'll have the Rollison trial.
Okay, let's just talk about Ms. Smith's first, and then we can talk about it. So, June 6th. How many on the veneer?
30.
Okay.
Yeah, I'd say 30.
Okay, so Ms. Smith, that means that you need to be back here Thursday at 12:30 for motion hearings, okay?
Next Thursday?
Yes, ma'am, a week from today, 12:30, because the state has motions in limine, which means they don't want the jury to hear certain things. They don't think legally they shouldn't be able to hear certain things. I don't know what those are. Mr. Koch will stay in touch with you regarding that. And then you'll need to be back, plan on being back here Thursday, June 6th. So that's 2 weeks from today at 8:30. And that would be to go to trial. If I can cover it, then I'll do it. If not, I'll try to find another judge to cover that. But I'll know that for sure a week from today. Okay? So Thursday, May 30th, a week from today at 12:30. Okay? Good. Thank you, ma'am. And just before you leave the lectern, is the state withdrawing its offer to Ms. Smith, or are you going to leave it open until Thursday?
I don't have a reason to withdraw. So
Okay.
And Your Honor, I'm just going to hand my client a card showing that Thursday, May 30th at 12:30, and then, of course, Thursday, June 6th for the trial at 8:30,
Good.
just to clarify.
Okay. So Ms. Smith, just know that the state's going to withdraw that offer on Thursday, a week from today.
He said he wasn't.
You're not withdrawing it now, but you're going to withdraw it a week from today, right?
at that point, yes, she's,
Right.
if she determines between now and then, I would still hold it open.
Understand.
Yes.
So Ms. Smith, just know that the state intends to withdraw that offer a week from today, and I will see you at 12:30, May 30th, okay?
Okay, thank you.
Thank you, ma'am. Okay, who's next?
Correct, I don't have any points this week. Here, you call the office and see what it's squeezing. Judge, I'm ready on Mr. Gary Rollison,
Okay,
case 23 CF 2199.
thank you. Hello, Mr. Rollison. Good morning. Good, how are you? Are we going to trial on Mr. Rollison's case?
The defense, yes, is,
Okay, is there any offer to Mr. Rollison that the state intends to withdraw if it's not accepted today?
It's 48 months Department of Corrections.
Okay. And what's the maximum that Mr. Rollison could be sentenced to? Mr. Rollison, the reason why I asked that is not to scare you or to coerce you into doing anything. I just want you to know your maximum downside. And then if you decide you don't want to accept the 48 months, we'll schedule the trial today, okay?
it was 4 counts, Your Honor, possession of firearm by convicted felon, so the max would be 60.
Okay. Mr. Rollison, do you understand that? Okay. Do you wish to accept the state's offer of 48 months prison? Okay. You wish to go to trial? Okay. So how many days will it take to try Mr. Rollison's case, including picking the jury?
Judge, I believe 2 days, but
Mr. Snow?
it's gonna be 2, because I have at least 5 witnesses, so.
Okay. And you want to set it for June 4th, Tuesday, is that what you said?
That's correct, yes.
Any motions you want heard on Thursday?
Yes, sir, I anticipate filing one. I believe the defense has already filed 2.
Okay. So then Thursday, May 30th at 12:30. So, Mr. Rollison, I'll see you back here on May 30th. That's a week from today at 12:30 for motion hearings. And then we're scheduled to go to trial on June 4th, which is a week from Tuesday, beginning at 8:30. And we'll talk more about that next week, okay? How many on the veneer? Thank you.
Withdraw that
How many, you're asking the question?
Correct, on the veneer?
Probably 40 on this one.
Okay.
I'd agree.
Okay, Mr. Rawson, I'll see you a week from today. Thank you, sir.
Your Honor, I have Mr. McLean.
Thank you. Thank you.
Your Honor, this is Mr. McLean. He's present and approaching. We have reached an agreement to resolve this case. At this time, Mr. McLean is going to be entering a no contest plea to the lesser included offense of sale, manufacture, or delivery. The agreed upon terms is that Mr. McLean will be sentenced to 11 months, 29 days in the Okaloosa County Jail with credit for all time served. That will be followed by 3 years of probation. That probation will automatically early terminate at 24 months if there are no violations. He would be assessed $615 in court costs, $150 in public defender fees. He has previously been adjudicated. We did talk with the state, and the state would be okay with the plea being entered today, and Mr. McLean is going to request that the sentence be imposed on July 8th. And the reason why he's asking for such a lengthy time from today is he has to take steps to figure out what he's going to do with his daughter, and he's got quite a bit of animals that he needs to figure out what to do with. So that's the reason why we're asking for the July 8th date. I know that that is docket day / calendar status, but this would be a situation when he comes in just to get formally sentenced.
Okay.
And
And Mr. McLean would have to pay the $40 per month cost of supervision.
I was just about to ask if the court would consider waiving that, given the fact he's going to be serving a year in county jail and coming out with essentially having to start all over again.
Okay. Mr. McLean, if you'll raise your right
Should I
hand.
approach?
And Your
Please.
Honor, this is a downward departure for the purposes of an uncoerced legitimate plea bargain, Your Honor.
Thank you, sir. Mr. McLean, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Mr. McLean, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
So before I talk more with Mr. McLean about the plea agreement, what happens if Mr. McLean doesn't show up at 9 o'clock on July 8th for the sentence?
Your Honor, if Mr. McLean doesn't show up, or if he picks up new charges between now and then, this would constitute an open plea to the bench. The court could sentence Mr. McLean to anything the court wants, basically.
Well, up to 30 years according to the plea agreement, right?
I believe so, but it's a plea to a sale, manufacture, delivery. I've never really had a situation come up where somebody pleads to a lesser included and then fails to appear. So I think that probably accurate to say that the state could move to withdraw the plea or ask the court to not kick the plea back.
And I would argue, Your Honor, if he doesn't show up, the state is going to argue that the whole reason why we entered this was an agreement between the parties that we're reducing these charges in exchange for a reduced plea. So it's one of those situations where if he doesn't show up, then we are going to be seeking an imposition on the original charge.
So the plea agreement would be rescinded.
That's correct, Your Honor.
I think that that's probably an accurate statement. of the law. Now, obviously, as a defense attorney, I would have to fight that, but I think that that is inaccurate. Because a plea agreement really is,
It's a contract.
it is. I mean, well, I won't concede that point, but it is an agreement, and if somebody doesn't follow the agreement, whether it's a defendant or the state, then the other party can ask. I mean, defendants frequently ask to withdraw pleas if something comes up from the state. So I think reversing the polarity, so to speak, I think the state can do the same thing. So,
Okay. Mr. McLean, I just want you to know what this court would do, what I would do. If you don't appear at 9 o'clock on July 8th, then I would rule that the plea and sentencing agreement is void, that it doesn't have any force or effect because the terms of it weren't fulfilled. Basically, it wasn't accepted by you by fulfilling the terms, one of the terms of that plea agreement. So then you'd start back from scratch with no plea agreement, have a possible downside of 30 years in prison. Do you understand that? Okay. And I put that on the record where I'll also, one of the attorneys said, wait a minute, here's what you said on the record, because I want you to know what happens. Have any questions for me or your attorney or the state? Okay. Do you understand what I just said?
yes, sir.
Mr. McLean, I do accept your plea. Your sentencing is set for July 8th at 9 o'clock. Okay? Thank you, sir. Okay. Hello, Lynn. Good, how are you? Good. All my counselor now gone?
I think we could probably take Ms. Mott. I know the status of what we're doing, and just for the sake of, it's Mr. Klein's.
Mr. Kleins? Yes, ma'am. Mr. Kleins, we got Ms. Mott on Zoom and then the folks in the gallery.
Can we approach?
Yes, sir. Ms. Mott, if you'll unmute your microphone, Ms. Mott. Ms. Mott, can you hear me? We can't hear you, Ms. Mott. Your mic's muted.